Welcome back to the PI show. Before the break, we were discussing mediations and alternate dispute resolution. And one point is this is trying to reduce the time matters are in dispute.
Yes, and the delays getting a court case
and
on.
costs, which
Yes.
are significant.
Yeah, costs. Well, what's been the history? I mean, I think when I started off in law, you could have 4 or 5 years in court before the matter reached a trial.
Yes.
That doesn't happen anymore.
No, prior to, back in the early 80s, they had what was called, in legal terms, a green book for all the cases awaiting trial in the county court. Believe it or not, there were 60,000 cases, and the then registrar put
It's a scary number, Martin.
It is. The then registrar put his hand up and said, we're going to have some conferences and we're going to try and resolve these matters. Believe it or not, again, over a few years, they got together with all the parties and they worked through that list until that book had a very small number of cases awaiting trial.
So these days, what's the delay in, let's say, issuing court proceedings and getting a trial in Victoria?
Probably 12 months.
12 months. Well, that's not...
No,
that's
at least, no, it could blow out to 18 months sometimes. You've got to go through various steps before you can get to court. Interlocutory steps, which is discovery and interrogatories and things like that. So that can delay it because...
But that 12 months sounds reasonable.
And if you don't...
That sounds reasonable.
If you get to court in 12 months' time and something goes wrong where witnesses are unavailable...
You've got to adjourn.
One of the parties wants an adjourn for whatever reason, then you might have another 12 months to wait again.
To get a trial
and by
date.
the way, you know, discovery interrogatories is part of a process where parties exchange documents and ask each other questions.
Hopefully cards on the table.
Yeah, well, it's to try and reduce the issues between the parties.
However, the major insurers in Victoria, in the, as we called them, the hybrid systems when we discussed them last week, that being WorkCover and TAC, they have put ministerial guidelines in place and protocols in place. Mr Hulls, the Attorney-General, in a October 2004 announcement, he says that they're making changes, that the protocols for fast-tracking the delivery of benefits for those entitled to compensation and to reduce legal costs, as you said, Tony, to resolve claims without unnecessary delays. This agreement will mean less matters are referred to the courts and a more accessible, efficient and less costly outcome for people injured on our roads. They actually came up with some protocols. I brought along a copy of those for people to see or to discuss if they need to. Those protocols have worked very well, and in fact, the application, which we've discussed previously for serious injury, is dealt with by those protocols.
This is with the Transport Accident Commission.
And then after you do successfully succeed and get a certificate, they then have a conference held within 90 days. Now, 70% of the matters are settled in that short period of time. So that's a remarkable turnaround.
And the good thing about TAC too, Martin, is that you've got to have a conference before a trial.
Yes.
And they're pretty good at reducing matters. And plus the TAC, what they've done is they've handed over surveillance and all sorts of things. So
as we discussed,
the plaintiffs can go back and view the surveillance.
Yep.
But the protocols, you say TAC protocols are working?
I believe so.
And what about WorkCover?
WorkCover are getting there. They've got a more rigid system which was introduced back in, I think, 2001. They had the ministerial guidelines. Certainly they have...
The minister's changed since then.
Yes, but certainly since
the guidelines haven't.
No, but it's interesting, Harry. Things are changing. Recently we had some judge-driven mediations, and we've recently had now what you would call some bulk conferencing taking place. Those situations are...
But you'd be pretty keen on WorkCover,
but
handing over surveillance tapes and...
Yeah, we discussed that in the surveillance show.
But that's the bulk conferences are still in the context of litigation. That is the matters are on foot. They're in court. There is a dispute. And
the only exception to that, Harry, is when you make your serious injury application in its first instance. If they give you a serious injury certificate immediately, you can then go to
the next stage.
conference.
You have to have a conference before you issue.
Yes.
There's got to be offers and counter offers also in writing.
Yes.
And it's a bizarrely complicated system.
A lot of hurdles to overcome.
Right? It's been designed by bureaucrats, dare I say.
And for the poor accident victims out there, for them to get their heads around it, I don't think they've got any hope. They've got to go to a lawyer, they've got to sit down with their lawyer and go through it step by step.
There's so many hurdles to overcome.
To get a result.
Yeah, and so many extra costs, I think, associated with all these steps.
Yes.
That, in fact, if anything, it's probably reducing the amount of the awards.
It's extremely complex. I don't know whether it is reducing the amount of the awards, but it's a difficult process, as you said, to get onto court.
You know,
But yeah, there are disputes, and you know, some disputes ultimately have to go to trial because the parties can't resolve it. But you're saying, in effect, most disputes are resolved prior to going to a verdict, which is encouraging. So WorkCover, I think, have what's called conciliations, and if you've got a dispute about weekly payments and medical expenses, you have to go to a conciliation.
that's a pre-litigation step which you have to take.
And they're reasonably successful?
They settle, yeah, a fair proportion, but you'll find that quite a few don't settle, and then proceedings have to be commenced.
Yeah, but that's again, the parties get together. It's informal.
They do. There's no lawyers involved, or very few occasions when lawyers can be involved. It's got to be by agreement of the parties, and more often than not, it's to keep the lawyers out of the picture.
But
keep lawyers out of the picture. I would have thought the lawyers play an integral role.
But they keep them out of the picture.
At
because
conciliation.
they try and keep costs down.
I understand.
at
Yeah,
conciliation.
Yeah.
But you know, as a practicing lawyer, we agree lawyers do play a role, and it's important for people to get.
What normally happens at conciliations is the clients speak to the lawyer before they go to the conciliation for some advice about what happens.
Yep.
And so, in effect, you're trying to preempt or predict or whatever
Explain
what
the situation.
might happen.
Yep.
Yeah, yeah.
So that's conciliation. So that's pre-trial, and there's protocols with TAC. But
We actually encourage more and more conferencing, mediations, arbitrations, whatever you want to call it,
Yes.
because I think it's beneficial to the community in general.
But there's no barrier for parties to commence negotiation at any stage in a dispute.
There's not, but if there's some sort of something hanging
The
over
parties,
their head,
parties are reluctant to enter into discussions or negotiations, often in fairness, often because all the information is not available.
yeah, but you can start something, Harry, and you'll find that maybe you can narrow the issues pretty quickly if the parties do get together. You need a third you need an umpire. The umpire could be this barrister or someone that can assist.
Yeah, but as I say, historically, a lot of lawyers are reluctant to enter into any negotiations early on. There's various reasons for that.
Yeah.
But that's all we've got time for in this segment. We've got to take a break for our sponsors. We'll be back to wrap up the show after the break.
Thank you.